with this agreement. Mr. Samuel has worked very hard and is very passionate about helping you, and I appreciate that. My position on this is based on a couple of things. One, the horrendous nature of this offense. Rojas on Jeffrey Ainsworth. Oh. So, Mr. Ainsworth, you tested positive for marijuana. When's the last time you smoked marijuana?
The week of New Year's.
I don't believe that. When's the last time you smoked marijuana?
It was the week of New Year's, but like a 30-day period.
So you smoked a lot?
More had I wouldn't say I smoked.
And what you put all of your children through, all 10 of them, is beyond anything that I have seen in 30 years of practicing law. 30. And so you're not walking out of here today. My initial thought was some upfront time, but if I'm going to stick you in jail, then I might as well put you somewhere where you're getting some help that you need, so that when you are released, you hopefully will be able to be a productive part of our society. But whatever trauma you've been through is incomparable to the trauma that you've put your children through. So at this time, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. I'm going to follow this agreement only because of the work that Ms. Malfino and Ms. King and your attorney have done, and the agreements that they've reached, and I understand why. Part of that is so that your children don't have to be re-traumatized and come back here for a trial and testify against you. I don't want to re-traumatize your children, and that's the only reason I'm really going along with this. So I will defer all proceedings, place you on probation for 10 years. You will be ordered to pay the $1,000 fine and follow all of the rules and conditions of probation. One of those is going to be that you enter and successfully complete the special needs safety program. You will be on the mental health caseload when you're released, and you'll have aftercare through Spindletop. That is now part of your probation. So if you don't follow through with any mental health services that are recommended through Spindletop or probation, that's going to be a violation of your probation. You will also be ordered to remain in Jefferson County, Texas. You cannot leave Jefferson County without permission. You cannot go anywhere near or see your children. You've terminated that relationship. I know they're with family. And so there's no Christmases where you show up or they bring the children down or anything like that. That's done. That's over. If you want to leave Jefferson County, it has to be with my permission, and I will have to know where you're going and to what extent and things like that. If you do everything you're supposed to do on this probation, I cannot stress enough what kind of opportunity this is that you're being given. If you, however, violate any condition of probation, if you're back here in court, obviously this isn't a case that I will ever forget. And Ms. Malfino will also, like she said, if you violate probation and come back in here, depending on the case, what you violated and how you violated, you could go to prison for anywhere between 5 years and up to the rest of your life in prison. Do you understand? Yes. I'm handing you the trial court certification that shows this was an agreement and I followed it. So you've waived your right to appeal. So you can go, that's for her. You can go back with the bailiff. Thank you, Ms. King. Thank you, Ms. Malfino, Mr. Singh. As I've visited with the attorneys, and for the record, we have also Ms. Randy King here, who is the assistant district attorney that handled the termination and CPS kind of portion of this case with regard to the children. I've received, has everyone had an opportunity to review the pre-sentence report?
Yes, Your Honor.
Are there any additions or corrections to that report?
No. No additions or corrections.
Ms. Smolfino?
Judge, I would just ask the court, take judicial knowledge of the conversation we have had with the court and the understanding that this has been discussed at length upstairs. Ms. King has also provided me a tremendous amount of guidance, which I thank her and appreciate everything she's done with her wealth of knowledge and experience in guiding me through this case. I know the facts themselves are extremely egregious. It's difficult for all of us to look at. I would recommend Ms. Schultz is getting this opportunity because she has availed herself of certain things and tried to make progress. The children, her rights have been terminated, which she voluntarily gave them up, and they have been relocated out of state to a stable environment to where they will not have to testify against their mother, which was something that we took into a great deal of consideration. I would ask the court consider special needs safety in lieu of ISF cognitive. I think it is a more lengthy and a more appropriate term in custody as either an upfront type of sanction, but more so to give her the tools to be successful on this probation, because as the court is aware, and I'm sure Mr. Samuel has advised Ms. Schultz, and I do not mean this statement to seem punitive, but if Ms. Schultz is back before you on a violation of this probation because of this opportunity she's been giving, the amount of time that the state will be asking for will be overwhelming.
Thank you, Ms. Smolfino. Anything, Mr. Samuel?
Yes, Your Honor. I understand the position of the state. However, I have to look at things from the position of the individual. The pre-sentence investigation report shows that she has no prior criminal history. It shows that she has no drug problem. There is a question about the alcohol. However, we believe that that can be done without the need of the inpatient treatment of the ISF. We believe that she's finally working. That is one of the most important things that she has to deal with in what she's gone through. She's experienced the trauma of relationships, and I think all of that is stated in the pre-sentence investigation report. But what you do not hear is the experience with the other partners of the children. She has carried this burden. She has tried to do the best that she could at the time. She's educated, she has a degree, but she has not been able to find employment. She's finally working in her, and we just ask that this be held in abeyance for at least 90 days. That will show if there's an alcohol problem. That will show if there are other problems that she's experienced. She has been to a mental health specialist for counseling, and she will get with them again. And we believe that if that is a part of the order for mental health compliance and conditions, she can do that. But let her prove to the court that this is not just her as it is today. This is a result of everything that she's experienced in her life at this point. I just pray that the court will have mercy on her and give her that opportunity.
Well, Ms. Schultz, you're getting mercy today. You're getting mercy from these ladies as well as myself, if I go along with this agreement. Mr. Samuel has worked very hard and is very passionate about helping you, and I appreciate that. My position on this is based on a couple of things. One, the horrendous nature of this offense. Rojas on Jeffrey Ainsworth. Oh. So, Mr. Ainsworth, you tested positive for marijuana. When's the last time you smoked marijuana?
The week of New Year's.
I don't believe that. When's the last time you smoked marijuana?
It was the week of New Year's, but like 30 periods.
So you smoked a lot?
More had I wouldn't say I smoked. I had asthma. I can't really smoke. I did have just 3 days in a row.
You did what, 3 days in a row?
Edibles. Yeah, I'll take accountability for that.
Well, I appreciate that, but you're here on a felony. and you're waiting on sentencing on a felony where you're getting this great deal with the deferred probation and you make such a dumb decision. How old are you?
So,
I'm going to find that you previously entered your plea of guilty freely and voluntarily. I'm going to, excuse me, find sufficient evidence to find you guilty. I'm going to follow the agreement that you made with the district attorney. I'm going to defer all proceedings and place you on probation for 4 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. One of those is going to be, well, a couple of things. One, I want a substance abuse evaluation done just to see if there's any underlying issue that needs to be taken care of. And if so, whatever treatment they recommend, that's what you have to do. In addition, I am going to order that you wear a drug patch for some amount of time between now and whenever probation feels like it's been long enough. You need to have that drug patch on within 24 hours. If it tests positive, which I understand that it may this first time because there's obviously still something in your system, but those drug patches also give a quantity, not just a positive or a negative. And so that quantity should be going down. Do you understand? If it's staying the same, if it's going up, then I have no choice but to believe that you are using marijuana again. You're going to end up, what I'm going to do is if there's a positive drug patch, probably after the first one or so, I'm going to let probation work on this. Then I'm ordering right now that you enter and successfully complete the substance abuse track of the ISF program, but I'm going to hold that in abeyance. So let me explain what that means. ISF is a 90-day in custody treatment program. I'm not going to make you go today, but if you test positive for marijuana, again, probation doesn't have to come to me. All they have to do is send a paper over. I sign it. There's a warrant issued for your arrest. You go into custody and then you go to that treatment program. You understand?
Which one?
So this opportunity is an excellent opportunity that you're being given today because you don't have a felony conviction on your record. You'll never be a convicted felon if you successfully complete this probation. At the end, the case is actually dismissed. If you violate, though, you could be brought back into court, found guilty. So you become a convicted felon, which will ruin your life in many ways. And you could go to prison for between 2 years and up to 10 years. Do you understand? So if you're, whatever it is, edibles, smoking, whatever, even if you think it's not the illegal kind or whatever, if you test positive, you don't need to use anything at all that could potentially test positive for THC. Do you understand? If you're having issues with that and there's some type of issue, then you need to talk to probation. Because if you ask for help up front, they might get you some outpatient treatment instead of this ISF. But if you don't and you test positive, you're gone. Okay. All right. I'm handing you the trial court. Sorry, I'm gonna hand you the trial court certification that will show that this is an agreement that I followed. And so you waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up when they're ready to go over your paperwork. Good luck to you, sir. Just anywhere in the court. She's going to call you up to her desk. So just listen for your name. Good thing. How old are you? I'm sorry.
I'm 22.
Did you say you are or you are not working?
I just really stopped working.
I can't understand you.
I just really stopped working like 2 weeks ago.
And why was that?
Because I was sick and I slept in my work like 30 minutes trying to get better and they said I was needed to. But I'm looking for a job now.
All right. I'm going to find that you qualify for a court-appointed lawyer. I want to get something working on your case since you're on probation and we're having all of these issues that we've been having with regard to alcohol and things like that. I'm going to have you step in front of the clerk. She'll let you know who that's going to be. I also want to warn you today, if you test positive for anything, including alcohol, again, we won't even have a hearing. There will be a warrant that goes out for your arrest. You will be in custody and you obviously you already are, and you definitely will at that point be looking at your probation being revoked. Do you understand?
Yes.
So there's no slipping up. There's no taking a sip of a twisted tea or anything else that you're saying you're doing. If you do that, you're in jail and potentially going to prison. It's that important. Okay, step in front of the clerk.
What is
Stephen Gomez. Is this, Mr. Oh, that's Ben. Okay, hold on. Let's wait for Mr. Jeffries.
That's what happens.
Of child pornography and cause number 25 DCCR 1378. And what is the announcement?
The prosecutor and I have met about the case. We spoke last week and we spoke again this morning. There, I don't know if you want to speak to, there's some issues with the indictment. But the other are, since she has taken over the case, we're kind of discussing a resolution.
So I see that there was a motion to quash the indictment that was filed some time ago, back in December. What I can do is just reset it, Ms. French, since you're just getting on the case, give you some time to look at that indictment. If something needs to be amended, you can take care of that. If you think it's fine, then we'll have the hearing on the motion to quash at the next court date. And, or if you guys come up with some agreement, we can take care of that. But I'll just do a normal reset so you guys can look more into it. And
He's
then-
jumped into it pretty fast. We've had some really good.
Yeah,
pretty good
no, I have no doubt she has. She's jumped into them. So we'll do a normal reset. Stay in touch with Mr. Rennick so that once he gets any information, offers, things like that from the assistant district attorney, then you can visit with him and we'll see if we can get a resolution.
Thank you,
You're
Jeff.
free to go. Thank you.
Thank you, Your Honor.
Mr. Kelly, you have Davin Kalina.
He's present, Jeff. Thank you. No. Morning, gentlemen.
Good morning. Morning. All right, sir, are you Davin Kalina?
Yes, ma'am.
This is 24 DCCR 2432. Mr. Kalina is charged with injury to a child, elderly, or disabled individual. And what is the announcement?
Judge, I think we're on the goal line to a resolution. The court would allow a last reset.
Any issue?
Judge, Mr. Cat was on this for quite some time.
Yeah, I see that there
Mr. Millie has been on a shorter period of time. We're not quite there yet. We've kind of countered a couple of different things, made a few phone calls, but we're doing our best.
Thank you. I'll just do a normal reset. This, I know you haven't been on it very long, but this will be the last reset just because the case is getting long in the nature of the offense. And
Understood.
so make sure, Mr. Kalina, that you stay with get in touch and visit with Mr. Kelly before that next court date. Once he gets any final offers from the state, you guys can go over that and we'll get an actual announcement at that next court date. Okay,
Thank you, Judge. Thank you.
Mr. Kimler, I was holding on Raphael Glover. Right, so you're Raphael Glover, and Mr. Glover's case is set for trial to begin with jury selection next Monday and cause number 24 DCCR 0232. And what is the announcement?
Your Honor, the state had tendered a new offer today at 10/10. Mr. Glover's informed me that he's refusing that. We're still requesting a trial.
Great. Any
State's
issues?
ready for trial, Judge. We're ready.
All right, so Mr. Glover, I'm going to number the case for trial. Your case is very old. It's likely to be somewhere near the top of the list. After today, I will not accept this agreement. So you have every right, obviously, to have a jury determine if you're guilty or not. If they find you guilty, what your punishment is. But after today, we're not going to come back and do a probation tomorrow or Monday afternoon at the last minute. Today's the day for that, okay? All right, stay in touch with Mr. Kimler and your bondsman, and we'll see you back next Monday at 1:00. Okay?
Okay.
Do I have a drug test on, I don't see Ahmad LeBlanc? Did I already do that with him?
He's the one, he's still drinking water.
Oh,
He's in the back now.
Okay. Mr. Bruce Smith, you have Brian Barriere on a sentencing. Good morning.
Morning.
Good morning, sir. You Brian, is it Barriere? And Mr. Barriere was previously in court, entered a plea of guilty to the third-degree felony offense of placing a serial number with intent to change the identity. I've received that pre-sentence report and reviewed it. Have you all had an opportunity to review that?
Yes, Your Honor.
Yes, Your Honor, we have.
Any additions or corrections?
No, Your Honor.
Not from state judge.
All right, sir, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made and find you guilty of placing a serial number with intent to change identity. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections, but that will be suspended. You'll be placed on probation for 3 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, then for all practical purposes, your case here in court is over, and you'll be able to serve that 3-year sentence while you're out on probation. The other side of that, however, is if you violate any condition of probation, you can be brought back into court and you could be facing that 3-year sentence that you've already agreed to. Do you understand? I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Smith. All right, good luck to you, sir. If you'll just have a seat here in the courtroom, probation is going to call you up to her desk when she's ready to go over your paperwork. All right, good luck. And then you've got Cedric Franklin sentencing, Mr. Smith.
Yes, Your Honor.
Good morning, sir. Are you Cedric Franklin?
That's fine.
And Mr. Franklin, before I go forward with your sentencing, there was a couple of concerns I had with regard to maybe some previous drug use. I'm going to have you tested this morning before we go forward with sentencing. Have a seat in the jury box and we'll get that done. And then we'll go forward with sentencing. Fabian Hall sentencing, Mr. Smith. Good morning. Are you Fabian Hall? And Mr. Hall was previously in court, entered a plea of guilty to the third-degree felony offense of injury to a child, elderly or disabled person. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
I have to.
Are there any additions or corrections,
No, Your Honor.
explanations?
Yeah.
The PSI kind of gives me some hesitancy.
It gives me a lot of
His
hesitancy.
response that when he was given an opportunity seemed to overwhelmingly mitigate and minimize his role in his offense. Obviously, from the perspective, as Mr. Riley writes it, that he has no criminal history, doesn't appear to have a substance abuse issue, so to speak, that he would be a candidate for promotion, but based on the totality of everything, and especially Judge, his minimization of the alternates, I defer to what.
Yeah, and I would also comment that the PSI itself talks about the fact that there's several factors in the defendant's background circumstances that favor leniency in sentencing.
Well,
And
all of that depends on, he pled guilty to this. And then his version is, I was being a good father that I am. I took the kids to play. We laughed, we ate, we enjoyed. My daughter was feeling bad and I ignored the signs of sickness. She had a lacerated liver. And the allegation is that he kicked her. There's nothing in here. This is a complete denial of.
no, it wasn't meant to. I talked to him extensively about that, Judge. What he tells me, and I have not talked to the probation department who wrote that, is that, and what he would tell you, that he never understood the officer to ask him specifically what is his version.
This
of
is in
case.
writing. He wrote
And
this.
then he wrote this because he explained to you why. Go ahead.
Okay, so he asked me if there was anything else I wanted to say. I'll just let him know that yeah, I'm a good father and I do what I can for my kids. That was all.
But you were not denying the fact that you committed the offense.
So did you or did you not?
Oh yeah, I was that's what I was saying. Yeah, I played guilty to yes.
I know you pled guilty. I was here for that.
Mhm.
Did you do what they charged you with? So what is the status now as far as access to children? It looks like there wasn't cooperation with Child Protective Service, which also gives me some concern. What do you see your children now?
Yeah, I do.
Do you have a court order?
Not the one that I'm not supposed to.
No, I'm talking about a court order from family court or anything that they.
Did you go
Like
through family?
like visitation.
No, I wasn't given it.
Okay.
So you've got 5 children. And this says you live with your girlfriend and 4 of the children. Is that correct?
Yes.
But you did not complete the CPS service plan? CPS got involved, right?
Yes, ma'am.
And from what I'm reading, it looks like there was some resistance to following all of the recommendations and service plan from CPS. So
no resistance. I followed everything they asked me for.
Yeah, that was a surprise to us is we had understood that he had done everything they asked him to do under the family plan.
And so does CPS, did they give you permission to be
They told me I would
with your children?
will have to be supervised with it, and I have been getting supervised. They never told me anything out of ordinary.
So you're never at home with these children by themselves?
No. And I'm always at work, so never at home by myself.
Where's the 5th child? There's 5 and you live with 4?
Yes, ma'am.
Which one do you not live with?
No, that's Nakai Fields.
And who does Nakaya live with? Do you see her?
No, ma'am. They wanted me not to.
Right. So that's the victim in this office.
Yes.
So with CPS, what exactly did you do? Did you take a parenting class?
No.
You did not?
No, I really didn't know what I had to do. Nobody told me nothing. That's why I'm kind of confused about it.
Judge, if the court needs more information about that, it'd be very easy for me to obtain. If you might give us either a little bit of time this morning.
And we have no problem. As a condition of we have no problem as a condition of probation. Tell him, saying that he must complete the recommendations of the CPS as far as like a family plan and everything.
Well, and I don't know what their recommendations are at this point, and it doesn't necessarily look to me if it's anyway. So here's what I'm going to do. I'm going to find Mr. Hall that you previously entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. I'm going to follow the agreement that you made with the district attorney. I'm going to defer all proceedings and place you on probation for 7 years. You're ordered to pay a $1,500 fine and to follow all of the rules and conditions of probation. That includes entering and successfully completing a parenting course that is approved by probation. So at this point, since I'm not real sure where CPS is on this, I'm going to order myself that you do the parenting class. If CPS is still involved, I'm also going to order that you follow all of their rules and conditions, which does include that you not have contact with Nakia, and that you have no unsupervised contact with any child, including any of your own.
Yes, ma'am.
So if mom has to go out and go to the store, you don't get to stay home with the kids. Do you understand?
Yes, ma'am.
If you do, then it's a violation of this probation. You'll be right back here in court. If I find out about it, you could go to prison for up to 10 years. Do you understand? If you do everything that you're supposed to on this probation and figure out, obviously, better ways to handle the children, then at some point, if you completed all the classes and done everything that you're supposed to, there's the possibility of some further contact with your children. And this is an opportunity where you don't have this felony conviction on your record. And at the end of the probation, if you successfully complete it, the case will be dismissed. You'll never have this conviction. The other side of that, though, like I said, is if you violate any condition of probation, you'll be back here in court and you could be facing the 10-year sentence and the conviction. Do you understand? Or up to a 10-year sentence. I do want to make sure, it looks like if there is a referral for mental health services, you have to follow through with any of those, whether you feel like you need it or not. If probation has you assessed and they feel like there's some counseling or something that would help you, you will be required to do that. Also, you will be required to have a substance abuse assessment and follow any recommendations of that. So it looks like there has been some marijuana use in the past. And that for some reason is on, when's the last time you used marijuana?
Last year, say December.
So if I test you today, you shouldn't have anything in your system. Haven't seen the jury box. Let's test that before I go any further. We did some drug tests today.
That's what you're on.
Yes.
She does.
Which one? It's loose patrons.
It's on the phone. Just need to take them out. I'll be here in the afternoon and she was supposed to be until then. She said she'd be on her way. She's looking for work. It will take her a few hours.
Does she have a misdemeanor pending also?
I'm just going to say. She should be on the weekend. She thought she had
At 2, yeah. For sure, she should be already on her way.
Okay, so when I went to say it to you, I realized how that did not sense.
And this has a notation that this is an out-of-town bondsman and you called them specifically, correct?
Yes, ma'am.
All right, I'm not going to do anything about it. That'll stay the same. If she shows up, then today, at some point, then I'll reconsider, but she needs to get here today, even if it means reset her case. Mr. Smith on Cedric Franklin sentencing.
Sure.
Cedric Franklin.
All right, Mr. Franklin tested negative, which obviously is good. So at this time, any reason not to go forward with sentencing? All right, then, Mr. Franklin, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney and sentence you in accordance with that agreement to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that. You'll be on probation for 5 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do everything that you're supposed to on this probation, this is a great opportunity because you will be able to serve that 10-year sentence while you're out on probation. And if you violate any condition of probation, then you can be brought back into court. You could be your probation revoked and you can be facing that 10-year sentence that you've agreed to. Do you understand?
Understood.
I'm going to hand you the trial court certification that shows that this was an agreement that I followed. And so you waived your right to appeal. Do you have a question?
If I complete it successfully, would this go on my record?
Yeah, this is a conviction. It's on your record. And that's based on the criminal history. that you already have. You've already had 2 probations that were revoked. So your agreement was for the straight probation. I also handed you an admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Smith. All right. If you'll just have a seat here in the courtroom, probation is going to call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir. This was this Mr. Kevin Lane on Ahmad LeBlanc. All right, so on Mr. LeBlanc's case, which is 21-36444, we went through the motion already, which is a motion to revoke unadjudicated probation, where Mr. LeBlanc is on probation for the 2nd-degree felony offense of aggravated assault. He pled not true to counts pled true to counts 1, 2, and 3. I got a drug test done. Mr. LeBlanc tested positive for THC. And so obviously, when's the last time you smoked marijuana?
The day I had to turn myself in. But the probation.
What made you think that would be a great idea? So he pled true to a possession of a controlled substance, a new offense, testing positive. So at this time, Mr. LeBlanc, you're on probation already. I granted you a bond because of that deferred probation status, but the fact that you're on probation and on bond and testing positive for THC, there's clearly an issue. At this time, I'm going to find that it is in the best interest of you and the community that there is not going to be a bond. I'm going to withdraw your bond at this time and find those violations. And then what I'm going to do is have probation do an updated report. You've pled true that obviously there's an issue. There's a new felony offense. And so we'll get an updated report and then we'll see what we're going to do at your probation sentencing. Okay. You can go back with the bailiff. Go on the check after the day. Mr. Burbank, you have Kingston Walker.
I did, Judge.
That one goes with this. Good morning, sir. Are you Kingston Walker?
Yes, ma'am.
And Mr. Walker is charged in cause number 25 DCCR 0861 with tampering or fabricating physical evidence, and then 25 DCCR 0862 with possession of a prohibited weapon. Mr. Burbank, what is the announcement?
Asking for one reset, Judge. I just have to finish it up. It should be disposed of.
All right. Any issues, Mr. Smith? All right. We'll just do a normal reset. Mr. Walker, make sure you stay in touch with Mr. Burbank, visit with him before that next court date so that you guys can visit about your case, and we'll try to get an announcement at that court date. You're free to go, sir. Thank you. Yes, sir. Thank you. And good morning, Mr. Burbank.
Excuse.
You can get one on the end for work. Mr. Galmore,
Yes, sir.
you have Carlos Betancourt.
We have submitted a plea on that one.
I've got it.
Okay.
Have a seat.
Good morning, sir. Are you Carlos Mascora Betancourt?
Yes, sir.
And Mr. Galmore, will your client waive the formal reading of the indictment?
You will.
Mr. Betancourt, in cause number 25 DCCR 0798, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from May 6th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with?
Yes, sir.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Galmore?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. Also, the state would agree if you're eligible and everything else kind of falls into line that they would recommend expunction under Article 55A.101A2. Is that your understanding?
Yes.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Betancourt's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. On your way out of the courtroom today, you need to stop and talk to probation, and she's at that desk right over there. All right?
Yes.
Okay, we'll see you back at sentencing.
You know.
And then, Mr. Galmore, you have Christopher Stiles. Did you
Okay,
have
no.
your certification on?
I'll get that.
Did he sign it?
No, he has not, but I'll.
Make sure he does that before y'all leave, please.
Thank you.
Yeah, I brought Monday, someday. Well, it's been a full amazing. What it's been.
That's true, it was, huh?
Yeah.
We're probably on.
Huh? Yeah. The dog, I mean, it's not alarm, it's just normal, but everybody's on it. Yeah, there was a lot. Just good. All right, on Christopher Stiles.
We're gonna sign that one up, Judge.
Okay, I'll hold it. Thank you. Mr. Gertz, you have Shay Morgan. I don't see paperwork or a rejection, and this was the last reset. So do I need to hold it for a few
We've got
minutes?
a deal worked out to exchange restitution for dismissal. We are finalizing and working on getting the funds together.
How long
That's our
will that
issue.
take?
Probably 30 days realistically, but we'll get it to you and then we'll get it to the state and then they would just issue a dismissal.
But this should have been done. I mean, you've been on since last July. And I said this was the last one, and I think probably for that purpose, last month, right?
We're working on
Should I have given him alternative offers to resolve it? Should she not have it up front, or should she be able to come up with half of it up front? But
All right, 2 weeks. Ms. Morgan, you have 2 weeks. If you get the restitution by then, great. If not, then there needs to be something alternative done. There will not be another reset after that one. All right? We'll see you in 2 weeks. All right, Christopher Stiles, Mr. Galmore.
Yeah, sure. There.
Good morning, sir. Are you Christopher Stiles? And Mr. Gilmore, will your client waive the formal reading of the indictment?
You will, Your Honor.
I'll take it.
Sorry.
Mr. Stiles, in cause number 25, BCCR 0594, you're charged with the state jail felony offense of abandoning or endangering a child from April 28th of 2025. And how did you plead to that charge?
No contest.
You either did-
Under these circumstances, and Mr. Galmore could probably elaborate more, the state's not opposed to a no contest plea. I understand the court's policy on that.
Okay, you obviously understand better, and I typically don't allow that, but if the state is unopposed, knowing what my position is, then I'll.
A guilty plea under these circumstances could have some collateral effects that the state's not necessarily intended.
All right, so did you enter your plea of no contest freely and voluntarily?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Galmore?
Yes, ma'am.
Do you fully understand?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. I see here the agreement for a no contest plea, that there would be only supervised visits allowed with the child victim in the case, and also that the parties agree, if the circumstances allow and if I approve it, an expunction under section or article 55A or section 55A.101A2 in the expunction statute. Is that your understanding?
Yes,
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Stiles is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back for sentencing later. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right, we'll see you back at
Thank you,
sentencing.
Judge. Thanks, Judge.
Receive his previous one.
Okay, so where are you on being able to get someone hired?
I've been to 40.
Are you working?
Oh, no, no. I just currently lost my job like a week ago, but I'll be looking for a job to be on the instant.
So you've been drinking alcohol? Why would you be doing that if you're on probation and you're not supposed to be?
Yes, ma'am. I slipped on yesterday and took a sip or something.
You slipped up and weren't thinking. You've been on probation for a long time,
Yes, ma'am.
right? And now you've got a motion to revoke your probation. And I let you out on bond.
Right. Because I did that.
Have a seat in the jury box while I think about this. Is there any way to get Miss Kane? See if she's available. She is. Well, I just kind of want to know what. Let me do some more looking in a minute, and then I'll see if I need somebody. Joan Kraus. Good morning, you're Joan Kraus.
Yes, ma'am.
And Ms. Kraus, were you able to get a lawyer hired?
Ma'am,
Were you able to get a lawyer hired?
no, but I was planning on it. I didn't know if y'all wanted me to use my court-appointed one or I didn't know how that worked.
So have you been to court yet in front of me? It's
Yes, but y'all told me to get 3 lawyers on.
right. So when you were here last, I said, if you could hire a lawyer, get one hired. And if you were unable to, then to visit with at least 3. Did you do that?
Yes, ma'am.
So are you going to be able to afford, are you working?
I'm retired.
So if you're unable to afford an attorney, I can have you fill out some paperwork to see if you qualify for a court appointed lawyer. Do you want to do that or do you want to try to hire someone? Can you afford to hire an attorney?
Yes.
Okay, so I'm going to reset your case one more time. You need to get a lawyer hired before that next court date.
Okay.
Okay, if you'll come over in front of the clerk, she'll give you your reset notice. And Ms. Cross, you don't drive, do you?
No, sir.
Okay.
I didn't know.
That's okay. It's me, please. Luz Padron. Luz Padron.
Lou, Paul.
Thank you.
No response, Your Honor.
Bond will be forfeited for non-appearance and reset at 100,000. Brittany Davis. Good morning, ma'am. Are you Brittany Davis?
Yes.
And Ms. Davis, did you get someone hired?
No, it's kind of expensive, but really expensive. I'm not even working right now. But I went through.
Who'd you talk to?
The legal aid. I put in an application for legal aid.
Okay.
It's a place that help you get a lawyer, but they say it could take 6 months to a year. So.
Okay. So did you talk to any other lawyers like I told you to?
The first 3 that I talked to, wow, I talked to like probably 8 of them. But the lowest there goes like 2,000 to start off.
Do you have the names of the lawyers that I asked you that you talked to?
You asked me that last time. I was on.
Right. And then I reset you to talk to them more or get someone hired. So
I talked to Brenshaw. I can't remember their name. Brenshaw. There's one that's brothers.
Why wouldn't you write that down and bring it?
I wasn't expecting that I had to.
So it looks like you weren't what?
I wasn't expecting that I had to.
So if you're okay. If I tell you to go talk to some lawyers and bring me the names of the lawyers you've talked to, and you don't think you can remember them, then I would think just common sense would tell you to write them down so that you could tell me that you did what I ordered you to do so that you wouldn't go back to jail. Right?
I did do what you ordered me to do.
Okay. So I ordered you to bring back the names as well, not just talk to them, but bring back who you talked to so that I know who you talked to and that you're doing what I asked you to do. Right? Right.
The cheapest ones that I've given you the last time I was here is the main ones that I was looking into.
Okay. But when you left last time, I gave you specific instructions.
Okay.
Right?
Right.
Okay. So are you wearing your drug patch?
Yes, ma'am.
So it looks like back on second. So you tested positive since you've had that drug patch on for methamphetamine.
What is that? Yep.
What does that mean?
I don't, but with the patch.
Mm-hmm. Looks like you tested positive for methamphetamine, cocaine.
Uh,
Hold on. Let me print it out so I can read it better. So last time you were in here, you had an issue because you had showed up with your drug patch in your hand, so they couldn't test it. So I tested you in court, and then I made you get the drug patch put on again and told you to keep it on. And then the drug patch that was put on January 25th. Which was the day before that court date. So you had one on, you had taken it in, you put it on, tested positive for methamphetamine and cocaine. Have a seat in the jury box. I'm going to have you tested this morning, and then I'll decide what to do. Thanks. Actually, come on, ma'am. Come on back up here. I know what I'm going to do. So, Ms. Davis, obviously it is a violation of your bond conditions to use any illegal substances, right? And so you tested positive for cocaine and methamphetamine on that drug patch, in addition to in the past not having it on correctly, and you didn't do what I asked you to do or ordered you to do also here. So I'm going to raise your bond at this time for those violations to $100,000. You will keep your court-appointed attorney while you're in custody. They'll be out to see you, and we'll just see what we do with your case at that point. You can go back with the bailiff.
wow.
Ma'am, come on back again.
Oh, you want an example out of it? Let's see.
I'll make an example out of anybody. Hang on. You want to stand here?
You don't.
You want to stand here and be disrespectful?
No,
I will make an example.
Understand my situation. Like,
I don't care what your
I'm not
situation.
making no excuses.
Okay.
I take accountability.
Right. So you tested positive for methamphetamine and cocaine.
I don't know how the patch work, ma'am. I haven't been doing any drugs.
Well, you did something.
I don't know if that's like the patch pick up sweat. I don't know if that's like after the process or what, but I haven't been doing anything.
All right. Go back with the bailiff. John Richard. Good morning, sir. You're John Richard?
Yes, ma'am.
And Mr. Richard, is it Richard or Richard?
It's Richard.
And Mr. Richard, this is your initial appearance and cause number 25 ECCR 0786. You are charged with, get it pulled up. The third-degree felony offense of failure to comply with sex offender registration requirements from April 30th of 2025. And since you've made bond in your case, have you had an opportunity to hire a lawyer?
No, ma'am, I haven't. This was all just a misunderstanding. My sister had reported me missing.
Well,
But-
and so they've indicted you for it. So it's probably really important that you get a lawyer. Okay.
Yes, ma'am.
So that if there is some issues or some information that lawyer can get to the assistant district attorney that would work out your case, then that's how that kind of works out. Okay.
Yes, ma'am.
So what I'll do is reset your case about 30 days to give you some time to try to hire a lawyer. If you,
I can't afford a lawyer because I don't work and I'm trying to get my disability and stuff.
okay, but you do not have disability yet?
No, ma'am, I don't.
Okay. So why aren't you working at this point?
Because I can't.
Why?
Physically, my knees are bad and I have arthritis and pancreas and.
There's lots of jobs for people who don't need to use their knees or different things like that, right? Do you have a lawyer helping you with your?
No, ma'am, I don't.
So have you actually applied for disability yet?
Yes, ma'am, I have, but I've been turned down.
Okay, so if you've been turned down, then I'm going to expect you to at least try to hire a lawyer. Okay, so let's go through, figure out if you can get one before that next court date. If you get someone hired before the next court date, then just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and we'll discuss your options. Also, in the meantime, I expect you to try to find work. All right. There's plenty of jobs out there that are not physical, that you could work with arthritis. There's people who work with that and have much more disabilities and still get out there and do something to make some money. So I want you to bring me a list of or proof of what you've done to try to find a job as well. Okay. Step in front of the clerk. She'll give you that reset notice.
Thank you.
Richard Volery. Good morning, sir. You Richard Volery? And Mr. Volery, were you able to get someone hired?
I don't know what.
All right. Did you talk to some lawyers?
So,
Who'd you talk to?
Brittany Holmes, James Martin Aiken, Mr. Getz,
Bert.
Jeremy Jeffries.
Say the last one.
Jeffries.
Uh-huh.
Thomas Kelly, and Mr. Roebuck.
Okay. And
they signed on the bank.
perfect. Thank you so much for doing what I asked you to do. Where are you on being able to maybe get someone hired?
Unfortunately, I'm unable to because I'm on disability. So
You are on and you receive disability. How much do you receive? Okay. So I'm going to find that you qualify for a court-appointed lawyer. Thank you for bringing that paperwork with you. If you'll step in front of the clerk, she will let you know who that lawyer is and give you your instructions on contacting them. Okay. Thank you, sir. Step right over here. Tiana Hughes. Good morning, ma'am. Are you Tiana Hughes? And Ms. Hughes, did you get someone hired?
This Thursday I will, but I did speak with the.
Speak up, please.
This Thursday I will, but I have contacted Greg.
Okay, who are you gonna hire? You're gonna hire somebody this week?
Yeah, the bank, which is waiting.
Okay. So what I'll do, thank you, Ms. Hughes. What I'll do is I'll do maybe like a 2-week reset. That should give you time to get him hired, and then he can file the appropriate paperwork. If you get him hired, he'll tell you when that next court date is. Otherwise, I'm going to give you a reset today so that if anything happens and you're unable to hire him for some reason within that time frame, make sure you're back on that date to let me know what's going on. Right? 2 weeks, she's going to hire Mr. Burbank. Thank you, ma'am. Mark Ramirez. Morning, you're Mark Ramirez?
Yes, ma'am.
And Mr. Ramirez, did you get someone hired?
No, ma'am, but I got those names. And I have Charlie Ramos is hired right now for the other them. But we talked to, so I talked to Dustin Galmore and y'all appointed me.
Speak up, please.
Y'all appointed me Mr. Alex Parker and I talked to Brittany Holmes.
Okay. So are you wanting to hire Mr. Rojas because you have him on something else, or are you going to be?
We're going to talk about to see how we're going to proceed with the case whenever, knowing that the non-affidavits has already been signed for the prosecution.
Right.
So we're going to see how we're going to proceed from there.
So are you going to hire him to take care of this case then?
I would have to see how much my money coming in, we'll see how it would work out.
Are you working?
Yes, ma'am. I work for the local 47 in Reason Hall, Alabama.
Okay, so you need to get Mr. Rojas or someone hired before that next court date so that they can get with the district attorney.
Yes.
Sometimes when someone files an affidavit of non-prosecution, it takes care of the case. Sometimes it does not. It just depends on the case and the district attorneys, how they feel about that. So you still need to get an attorney hired.
Yes,
and so you need to do that before that next court date, okay? All right, step in front of the clerk.
Okay.
Brandell Griffin. Good morning, sir. You're Brandell Griffin. And Mr. Griffin, did you get someone hired?
No, the last time I came, you told me I didn't qualify. I tried 6 lawyers, different lawyers. I couldn't afford them.
Who'd you talk to?
I gave you all the names of those two.
But since last time, who'd you talk to?
I went back to the same ones, just trying to.
Why would you go back to the same ones if you couldn't afford them before?
I talked to 7 lawyers. Like they all around the same price, 5,000 more. I can't afford that though. I didn't find anything lower than that.
Yeah. I mean, you filled out the affidavit and by law, you do not qualify. So
I'm trying to ask why is that
because your total income is $6,800 a month and your expenses that you put here are $2,260, which according to this means you have $4,600 left every month.
I told Anthony it was nowhere near 60.
You filled this out. I did it. And you swore under oath that it was true.
What did I sign? I get paid about $2,000 a month, and I pay child support. I have 7 kids. I pay child support for.
You put 0 on child support.
I put 0 on child support.
Well, no, you put that you pay child support for it. Yeah, that's all on here.
Yeah, I'm not understanding how it gets to 6,000.
I'm reading what you wrote. Unless I misunderstood. I'm sorry, unless I misunderstood some of the things on there or something. Like I can bring checks to bank accounts, all that. I can do all that. I can't. Hold on, I'm printing it out.
I was ready to finish this case and like I have evidence the girl to indicate.
I don't need to get it. I can't talk to you about that, but see, tell me. I mean, do you see the total on the left-hand column?
Because under assets, it has a car. My car is
the other side where you say your income is $6,800.
See that? But I added up assets, which is my car, and I had it worth around $6,000 on that. So I just added that number to that. Like I said, I must have did something wrong. I don't know. But
so you make how much a week?
I make like 18 an hour. I get paid bi-weekly. My check be like $1,200, $1,300.
So bi-weekly about $1,200 or $1,300. So total monthly is about 24. Okay. All right. So then based on that, you do qualify for a court-appointed lawyer. So I'm going to make that notation on here. You want to know, you may have them sit down. Step in front of the clerk. She'll let you know who your attorney is going to be and give you some more instructions. Brad Thibodeau. Good morning, sir. Brad Thibodeau. And this is your initial appearance, Mr. Thibodeau, in clause number 25, DCCR 0542. You're charged with the state jail felony offense of criminal mischief, impersonating public service from March 18th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Not impersonating, impairing or interrupting public communications, excuse me.
No.
Okay, so what I'll do, Mr. Thibodeau, is I'm going to reset your case for about 30 days or so to give you some time to try to get someone hired. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you burglary of a habitation and interference with emergency request for service. And the magistrate gave you a $25,000 personal bond and just let you were just released from custody.
Yes, ma'am.
After that date, on February 14th of 2026, you were arrested again, and that one for violation of a protective order.
Okay.
You made bond on that case, and you were given a $2,000 bond on that case. All of this information has been brought to my attention, and I am at this time, I've got Mr. Rojas has been appointed to represent you, and Ms. Malfino is here on behalf of the district attorney's office. Based on the fact that you were arrested for a violation of a protective order after you were let out without a bond really on the burglary of a habitation, I'm going to find that you're at large without proper bond on the burglary of a habitation case, which is cause number 26 DCCR 0328. I'm going to set that bond at this time at $50,000. There will be a condition of that bond that you have absolutely no contact or communication with
Allison
What's the last name?
Couch.
So that means in person. That means obviously communication or in person.
Yes, ma'am.
And if you will also be required as a condition of that bond, if you make it, to wear a GPS monitoring device at all times. Do you understand?
Yes, ma'am.
All right, go back with the bailiff.
Um,
You go back with the bailiff. Visit with Mr. Rojas.
okay. Yeah, I'm thinking.
I just wrote it on that. No, thank you. See, is Mr. Burbank here? Mr. Cole?
President John.
Good morning, sir. On Cameron LeBlanc, that's sentencing.
Yes, he's here.
Good morning.
Hey, Judge, how you been?
Good.
I'm hanging in there, Judge. Hanging.
Good morning, Mr. Coleman. I said good morning. I didn't hear you. All right, sir, you Cameron LeBlanc?
Yes, ma'am.
And Mr. LeBlanc was previously in court, entered a plea of guilty to the third-degree felony offense of evading arrest or detention with the use of a vehicle. I've received that pre-sentence report. Has everyone had an opportunity to review the report?
Yes, we have, Judge.
Yes, Judge.
Any additions or corrections?
Dishes and corrections.
Not from the state. We just asked you to follow the agreement of parties, Judge.
Thank you, Mr. Coleman. Mr. LeBlanc, at this time, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you don't have a felony conviction on the record. And at the end of the probation, if you successfully complete it, the case will actually be dismissed. You'll never have a felony conviction. The other side of that is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and go to prison for between 2 years and up to 10 years. Do you understand?
Yes.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. If you'll just have a seat here in the courtroom, probation's going to call you up to her desk when she's ready to go over all of your paperwork.
Yes.
All right, good luck to you, sir. Thank you.
Thank you.
See, Mr. Comerford, on J.C. Dunn, it's a sentencing. Good morning, Ms. French. Good morning, Mr. Comerford.
Good morning, Your Honor.
Good morning, sir. Are you J.C. Dunn? Or Jace Dunn, sorry. And Mr. Dunn was previously in court, entered a plea of guilty to solicitation of prostitution. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Yes.
Any additions or corrections?
No, you're.
All right, then at this time, Mr. Dunn, I'm going to find that you entered your plea of guilty previously, freely, and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney's office and defer all proceedings, place you on probation for 3 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have a felony conviction on your record. And at the end of the probation, if you successfully complete it, the case will actually be dismissed. You will never have a felony conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the state jail prison for between 6 months and up to 2 years. Do you understand?
Yes.
I am handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. You also just need to have a seat here in the courtroom. Probation is going to call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir. Thank you. Hope that's for him.
Oh.
Yes, sir.
There you go.
And then you've also got a sentencing on Ronnie Oliphant.
Yeah.
Good morning, sir. You're Ronnie Oliphant. And this is 25 DCCR 0379. Mr. Oliphant was previously in court, entered plea of guilty to the third-degree felony offense of injury to a child. I've received that pre-sentence report, and has everyone had an opportunity to review that report?
Yes, Your Honor. Yes, Judge.
Any additions or corrections?
Judge, just based off the statements and some discussions with Mr. Oliphant, we would ask to withdraw his plea. I understand it's up to your discretion.
So, Mr. Oliphant, obviously, I have some notations here. I know exactly what your attorney, Mr. Comerford's talking about. You denied the offense that you committed the offense in this pre-sentence report. But here's the thing. If I allow you to withdraw your plea today, which I don't have to do because you pled guilty after having sworn under oath that you were going to tell the truth the other day when you were here for your plea. If I allow you to withdraw your plea today, there will be no plea bargains whatsoever accepted. If you want to go to a jury and let them decide, then that's your right. If you didn't do it, then it's going to be up to a jury. We're not going to get down the road a few months and a jury's here waiting outside, and all of a sudden you're like, I really did do it. I'll take that probation or whatever it is. If we do this today, I am making a notation. Mr. Coleman, I'm sure, will notate it on his file. Mr. Comerford understands and has been here enough to know that when I say it this way, I mean it. So do you want to withdraw your plea and go to trial?
Yes, ma'am.
All right, then we'll do that and we'll set it on the next available trial docket. Mr. Comerford will.
Just docket wise, the next 2 weeks, I've got a suppression hearing one day, following week.
Oh, no. The trial docket will be, you're probably about 3 months out for the next trial
3
docket.
months. Okay.
Make sure if you have it, that kind of gets us close to in the middle of summer and stuff. So if
Sure.
you have any vacation, make sure you get that vacation letter in.
Yes, ma'am.
Look at that. I say Ms. Holmes will look at that before that's it. So if there's any vacation, otherwise it'll get set on the next one, which is about 3 months out.
Okay.
Okay.
Thank you.
All right. Stay in touch with your attorney. He'll let you know when you need to get back.
So
Nah, I wrote it on here. Mr. Galmore? Mr. Gertz? Ms. Holmes? You have Dylan Wilkinson? Good morning. Morning, Mr. Nichols.
Morning, Your Honor.
Good morning, sir. Are you Dylan Wilkinson?
Yes, ma'am.
And this is 25 DCCR 0260. Mr. Wilkinson is charged with deadly conduct, discharging a firearm. And what is the announcement?
Judge, can we call a name this morning?
Yeah, sure.
Samantha Grant.
Can we get, I think she has something going on up there.
Just kidding.
Let me get her back. Say it again, Samantha.
Samantha Grant. Yes, Your Honor. That's
Would you call the name Samantha Grant, please? Samantha Grant.
no response, Joe?
Your Honor, this case is about 1.5 years old, and during that time, I've had no responses to written or telephone communications sent to the complainant. Without any reason to believe she is pursuing the prosecution of this case, the state's going to dismiss.
All right, I'll sign that dismissal this morning. Mr. Boyd, that means your case is over. Obviously, if any, I'm sorry, not Mr. Boyd. Where am I? Mr. Wilkinson. Whatever went on, if anything, between you and Miss Grant. I don't know if y'all are still together or what's going on, but obviously you need to make sure and avoid any type of contact, probable with her or anything like that. You understand?
Of course.
All right, you're free to go, sir.
Thank you.
Mr. Jeffries, you have David Boyd. Good morning.
Good morning.
David. Good morning. Are you David Boyd?
Yes, ma'am.
And Mr. Boyd's case is set for trial to begin with jury selection next Monday afternoon, charged with deadly conduct, discharging a firearm in cause number 25 DCCR 0720. And what is the announcement?
We're ready with the exception of I am also on a trial docket in Polk County with an individual who's in custody. And he's at the top of the list over there. So
Okay. I'll take that. Is the state ready?
State's ready, Judge.
I'll take that into consideration. We do have a couple of much older cases here also, and so if for some reason it starts looking tomorrow like you may end up closer, then we'll discuss that a little further.
Yes.
Mr. Boyd, stay in touch with Mr. Jeffries. He'll let you know if your case is going to be numbered for trial and what number it is, and when you can be back next week. Okay.
Yes, ma'am.
All right. You're free to go. Thank you.
Thank you, Your Honor.
And then Stephen Gomez. And this is the, yeah. Stephen Gomez. Good morning. You see Mr. Gomez this morning?
He is something.
Good morning. Are you Stephen Gomez? This is cause number 21-37252. Mr. Gomez is on probation for driving while intoxicated, third or more. I received a memorandum from probation asking for a judicial review. Let's see, remind myself. Looks like you've went through the safety program and had the SCRAM and an ignition interlock device. The SCRAM was removed after safety, and you were ordered to JCDI for aftercare. After continuously testing positive for illegal substances on your drug patch. You received sanctions, testing positive for alcohol, and testing positive on your drug patch. You've now been in the program 9 months, but your most recent drug patch again tested positive for methamphetamine. Turned in a hair follicle. Okay. Have a seat in the jury box. Let's get a test done this morning, and then we'll talk about it a little bit more.
Absolutely.
Okay.
Step next week.
Yes, sure. This will take a few minutes. Mr. Kelly? Mr. Kimler, you've got LaAsia Clemens. Do y'all have a refusal on the tablet?
Emotion. Or emotion.
She was a small child. I was inquiring, she was nursing this as a small child. With her.
All right, are you LaAsia Clemens?
No.
And Ms. Clemens, in clause number 25, DCCR 1339, you're charged with the second-degree felony offense of robbery from September 9th of 2025. And what that means is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then I have here on the tablet a plea bargain rejection that you've signed with Mr. Kimler. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 5-year deferred probation and a $1,000 fine. You've got every right to reject that and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial? Yes or no? And is there any reason, I mean, obviously that offer is with a deferred probation, any reason to believe that that would change?
To my knowledge, Judge, Mr. Kimler has yet to review the video. So
I understand the facts from her on what happened. She was charged as a party to the offense. There was a chemical agent deployed by the co-actor in the course of attempted theft.
Okay.
She was no part of it.
So I want to make sure you understand, Miss Clemens, that after today, I will not accept this plea agreement. So if you want to go to trial, then that's what we'll do. We're not going to say later, oh, there's something that Mr. Kimler has or hasn't seen, and that's going to change. If I put it on the trial docket, it'll be a trial. Or if you change your mind and want to enter a plea of guilty, it would either be open to the court or to something different and not as good as this 5-year deferred probation. Do you understand?
Mm-hmm.
All right, then we'll set it on the trial docket. Mr. Kimler will begin preparation for trial.
Your Honor, did I hear the court correctly that the court would not give her, it would be worse than 5 years in an open plea?
No, that she would not be, this 5-year deferred probation would not be on the table at that time.
I thought I maybe misheard that the court said it would be worse than 5 years. She didn't accept it.
Not worse than 5 years in prison.
Oh, 5, I meant more than
But she's
5
not,
years.
this deal will not be on the table. So if you change your mind later, it'll be either open to the court or to something different, but not this deal. And if it's not this deal, it's also not going to be less than this deal. So I'm not going to accept y'all coming in here a day of trial and say, well, we'll take a 3-year deferred instead of a 5-year deferred.
Okay, that's what I understand. I think it should be from whatever the punishment range is, you know, what's available to the court, and it not be a prejudice.
That's not what I'm going to do. That's if y'all make a negotiation and want to come in and plea. If you plea open to me, it's anywhere in the punishment range. If y'all change your mind, then, and you want to enter some negotiated deal, I'm not going to accept this again.
If the court still in an open plea could go less than 5 deferred, would consider something less than 5.
I'll consider the entire punishment range as I'm legally obligated to do. All right. Stay in touch with Mr. Kimler and your bondsman. They'll let you know when you need to be back and ready for trial. Ready to go. Ma'am, also, you need to wear not tights or leggings next time you're in court. That's not appropriate.
Okay.
Raphael Glover, Mr. Kimler.
The state's made another offer on this just now. I wanted to run it by him before.
I'll hold it. And then what about Johnny Polanco Sr.?
We're going to reset. It just got the new case.
Mr. Smith, hold on. Johnny Polanco. All right, so you're Johnny Polanco?
Yes, ma'am.
And in cause number 24, DCCR 2168, Mr. Polanco is charged with aggravated robbery. I know we'd been waiting on a case.
It was brought over last week, but it was after it was too late to get it on for the grand jury. So
okay.
One more, you said we should have it indicted, Judge.
Okay, perfect.
He's going to need to post a bond.
So I'll just do a normal reset. Mr. Polanco, stay in touch with Mr. Kimler. Obviously, when that case gets indicted, I don't know if you've already made bond on it when you were arrested or not. If not, There will be a warrant. You'll need to turn yourself in, bond on that one if you can, and then we'll see where we are the next court date. All right, you're free to go, sir. And then you've got Jose Lopez.
I'll need an interpreter today than I will for trial.
Are you Jose Torres Lopez? And Mr. Torres Lopez is charged with solicitation of prostitution, set for trial to begin with jury selection next week. What is the announcement?
Great.
State is ready, Your Honor.
So, Mr. Kimmler, if a client needs an interpreter, if you need an interpreter for him, you're hired. Typically, that would be something that you or he would provide. If not, he needs to file an affidavit quickly of indigence in order to, or a motion.
I'll have an interpreter. I have my own. That's fine.
Okay. I mean, and if he can't afford it, then file a motion with that affidavit attached to it. But we need to know that once I number the case.
I think I could file that in good faith, Your Honor. So I'll have him.
Okay, then I will number the case tomorrow after the docket. Mr. Torres Lopez, stay in touch with Mr. Kimmler. He will let you know tomorrow the trial order and what time you need to be back and when on next Monday.
Talk to Marie. We'll call. Friday.
Mr. Kevin Lane, on Sean Dage Jr.
He's present.
Good morning.
Good morning.
Good morning, sir. Are you Sean Dage Jr.? And this is 24 DCCR 2353. Mr. Dage is charged with evading arrest or detention with previous convictions. And what is the announcement?
Your Honor, if we could just have 30 more days for an announcement. We've gotten an offer, we've gotten the written discovery, but we want to get the video discovery.
Okay. And it looks like you were just hired in January. Is that correct? Okay. Any issues? All right. I'll just do a normal reset. Mr. Dage, make sure you stay in touch with Mr. Lane so that when he gets all of that information, including any video, you can go visit with him, watch that, and then we'll get an announcement at the next court date. All right. You're free to go. And Mr. Lane, you also have Ahmad LeBlanc.
Mr. President, Your Honor, we have an open plea room to all counsel in the motion.
But no agreement.
No, Your Honor.
Okay. Get that.
Yes.
Good morning. Are you Ahmad LeBlanc?
Yes, Your Honor.
Mr. LeBlanc, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. Thank you. You can put your hand up. And will your client waive the formal reading of the motion?
He will, Your Honor. You want to read it again?
Mr. LeBlanc, in cause number 21-36444, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 19th of 2021 for aggravated assault, a second-degree felony, and that was a 5-year deferred probation. Is that correct?
Yes, Your Honor.
It alleges that you violated your probation. Count 1 alleges that you committed a new offense of possession of a controlled substance, penalty group 2, September 1st of 2025 in Chambers County, Texas. And is that true or not true?
True.
Count 2 alleges that you provided a urine sample August 3rd of 2022 that tested positive for marijuana. Is that true or not true? And then count 3 alleges that you're behind in your court assessed fees as of December 10th of 2025 in the amount of $480. And is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
True.
Did you plead true to those counts because they're all actually true?
Yes, Your Honor.
All right, then I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm going to reset your case for sentencing so that we can get an updated pre-sentence report. And then we'll go forward with sentencing. Before I let you go today, however, I'm going to get a drug test here in court. I want you to have a seat in the jury box and let's get that drug test done.
He does have a drug patch.
Okay. Thank you. So Boyd, he needs to be printed.
Yeah, is it unagreed?
It's unagreed, yes, ma'am. Mr. Lewis,
Yes,
you've got Janisha Jackson.
Yes, ma'am.
Good morning. Good morning, ma'am. You're Janisha Jackson.
Yes, ma'am.
And this is 25 DCCR 0903. Ms. Jackson is charged with abandoning or endangering a child. And what is the announcement?
Your Honor, if I may, before we get to an announcement.
Sure.
Something on this indictment should be cleared up. In reviewing for the docket this morning, it's come to my attention that the body of the indictment, which is controlling, is correct. It alleges endangering a child. The style of the document is incorrect. The allegation under E is abandonment without the intent to return, and that is a second-degree felony. However, what Ms. Jackson is actually being charged with in the body of the indictment is 22.041C, and that's a state jail felony. So Mr. Lewis and I have discussed that this morning and on Friday as well.
Any objection to me making that modification to the style?
No.
I'll get that done so I have it correct. Give me just a second if I can do this. It's 22041C.
Correct, Your Honor.
Sorry. Okay, got that modified on the indictment. And so then what is the announcement?
Judge, we've talked about potential resolution on this matter, especially with that the amendment we've discussed. If I can get maybe a week or two with Ms. Jackson, so I can explain that to her and the ramifications of that, we'll be able to get it finished.
All right, we'll do about a 2-week reset. Ms. Jackson, make sure you call Mr. Lewis, make an appointment, go visit with him so that when you come back, we'll get an announcement, figure out which direction we're going to head on the case. Okay. All right, ready to go. Thank you.
Thank you, Judge.
Thank you, Ms. French. And then I'm signing that dismissal in Clifford Norman's case.
Yes, ma'am.
Mr. Parker, you've got a sentencing on Samuel Cadena. What is this? Oh, there's a new, that's what. It is, yeah.
Window tint. Window tint.
Okay, so y'all already know that there's a warrant, but it doesn't have anything to do with this case, correct? Okay. Good morning, sir. You're Samuel Cadena?
Yes, Your Honor.
And Mr. Cadena was previously in court, entered a plea of guilty to the state jail felony offense of abandoning or endangering a child with intent to return. And I've received that pre-sentence report. Have you all had an opportunity to review that report?
Yeah, Your Honor.
Yes, Your Honor.
Any additions or corrections?
Nothing more of Judge.
Not from the state.
And Mr. Parker, are you appointed or hired?
Hired.
Okay. All right. So, Mr. Cadena, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay the fine of $500 and to follow all of the rules and conditions of probation. In addition to all of the rules and conditions that probation typically has, I am going to order that you are not allowed to consume any alcohol, and that for some amount of time you will be required to either wear a SPRAM device or use a handheld device, whichever probation feels is appropriate. You can talk to them about the benefits of one or the other. I don't care which one, but you will have to have one of those devices. Obviously, if you test positive, it's a violation of your probation for alcohol. If you don't follow any of the other rules on probation, they're violations as well. This is an excellent opportunity because you don't have a felony conviction on the record. And if you successfully complete the probation at the end, the case will be dismissed. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, if you don't show up, and more specifically and concerning to me is if you test positive for alcohol at any time, then you will be back here in court. You can be found guilty of the offense, and you could be facing a sentence of anywhere between 6 months and up to 2 years. Do you understand?
Yes, Your Honor.
If you have any issues with alcohol and not using alcohol, talk to probation. There is help that they can give you, but you need to ask for that up front, because if you test positive and then say, oh, now I need help, it might be too late. You could end up being revoked. Do you understand?
Yes, Your Honor.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Probation will talk to you before you go today. You will have to go with the bailiff because of that warrant, but she'll visit with you about what to do as soon as you're released from custody, okay? Good luck to you, sir. You can go back with the bailiff. Is that mine? It's Mr. Rennick. Mr. Samuel, you have a sentencing on Julia Schultz.
Hold that for just 1 second so I can get this cane.
Yes. Mr. Rojas, you've got a sentencing on Christian Ainsworth.
Let's do it all. Speaking is here, Judge. From
Oh, okay. Ms. Malfino, this is Christian Ainsworth sentencing. Mr. Ainsworth, I have a notation here. I'm going to have you drug tested this morning here in court before we move forward. If you'll please have a seat in the jury box, we'll get that done and let you take care of your sentencing. Have a seat in the jury box.
Miss King is here, Judge. I just can see what I'm saying.
Yeah, I'm going to hold that for just a second. I'm going to visit with you guys. Okay. Mr. Rojas, you've got Tashawn Bass, 2 cases. Good morning. Are you Tashawn Bass? And Mr. Bass is charged in each of his cases with aggravated assault, aggravated sexual assault of a child in cause numbers 25 CCR 0832 and 0833. And Mr. Rojas, what is the announcement?
Speaking with Ms. French last week, after exchanging emails, I think she needs more time to talk with the victims. It's a new case to her.
Sure,
She doesn't have had time to look at everything yet.
Okay. Anything else that I need to know of, Ms. French, or?
No, Your Honor, Mr. Rojas expressed that correctly. I would like to talk with the family and the victim before an offer is made.
All right, so I'll just do a normal reset to give Ms. French some time to get that taken care of. She'll get that information and an offer to Mr. Rojas before the next court date. Make sure you stay in touch with Mr. Rojas so that once he has that information, you can go over it with him and we'll see if we can get an announcement at the next court date. All right, free to go.
Thank you, Your Honor.
Thank you. And then it's Mr. Bruce Smith.
Right.
Mr.
The courtroom falls completely silent as the judge delivers one of the most emotional statements of the day. Looking directly at the defendant, the judge says that in over 30 years of practicing law, few cases have been as heartbreaking as this one. The court emphasizes that the trauma suffered by the defendant's 10 children cannot be ignored and makes it clear that the damage done to them will last for years. Despite the seriousness of the crimes, the judge explains why a negotiated agreement is being accepted. The primary reason is to protect the children from experiencing even more trauma by forcing them to testify in a public trial. Instead of sending the defendant directly to prison, the court orders 10 years of strict probation with mandatory mental health treatment, specialized parenting and safety programs, and constant supervision. The judge also imposes severe restrictions. The defendant is forbidden from contacting her children, cannot leave Jefferson County without permission, and must fully cooperate with every condition of probation. The warning is unmistakable. A single violation could send her to prison for anywhere from 5 years to life. Throughout the hearing, the judge balances compassion with accountability. While acknowledging that the defendant may have experienced trauma herself, the court makes it clear that personal hardship can never justify harming innocent children. The message is that justice is not only about punishment, it is also about protecting victims and preventing future harm. This emotional sentencing highlights how family abuse cases require courts to make incredibly difficult decisions. In the end, the judge offers one final opportunity for rehabilitation while making it absolutely clear that there will be no second chances if the defendant fails to follow the court's orders.